Mr. Lewison.
My lady, there is one point that I omitted to mention before lunch, which I will deal with very briefly, if I may. In all the mentions of fraud on power, I omitted to emphasise that we are not talking about fraud in the sense of dishonesty.
No.
And the best reference for this comes from Thatcher and Ball, which is behind tab 19, and there's a marked passage. Sorry, it's volume 1 of the authorities bundle, tab 19. There's a marked passage at 151 that makes that point clear. That is the only point that I wish to make in addition to what I said before lunch.
Thank you for clarifying that for us.
I'm grateful, lady. I'll hand back to Mr. Morgan.
Mr. Morgan.
Yes, so this is where I seek to dovetail with Mr. Lewison, if the court in due course is with us on the question of void and voidable.
Then we have to decide about the way in which the discretion was exercised.
Yes.
Under ground 4.
Indeed. And I'll just unpack that in a moment, but just as a point of fact, I'm sure the court is aware of, but the trustee who was sort of in position when the disposals was made, the 2011 and the 2012 trust, which is Pinotage PTC, no longer exists, because that was dissolved in the BVI in 2020. The trustee that was in position for the 2014 trust is still in existence, and that is the second defendant. I'll come back to that and how that unpacks in a moment. Perhaps I could just start by going to the judge's judgment. And we're in Core Bundle 1, tab 16, and page 307.
307,
my lord.
Yeah. Do you have a paragraph number, please? Because I'm not using,
Of course.
the one in the bundle. It's far too small for my eyes to read.
My lord, it's 354.
354. Thank you very much.
And I'd be grateful just for a moment so that I can clear the desk very slightly. Yes, so we're at paragraph 354.
Yes, where the judge had said, in the event I'm wrong, this is the exercise that I would have to engage in. And the point I wanted to start off with is really by inviting the court to read, I suspect, reread the quotation from Rice and Rice at 354. And then there's a short follow-on point at 355 as to how it's put in Snell. We haven't troubled the court with Rice and Rice and the bundle of authorities. We're content to proceed on the basis of the quotation from the judge. Obviously, if the court would find that helpful, we can arrange for that to be provided in due course. But the point that's being made there, which picks up on the point that Mr. Lewison made, is that irrespective of the bona fide purchaser defence, there may be competing equities where order of time is merely the tiebreaker rather than the primary rule, and where the court may take into account a range of circumstances and a range of factors in deciding where, as a matter of justice, a matter of equity, the position should lie in a voidable transaction. They may include late fees, may include affirmation, all sorts of things that will not be available in a void situation. And as the court will have seen, before the judge, we relied upon 4 factors. Inequitable conduct in relation to a lack of engagement, artificial tax scheme, counter restitution, and practicalities. Now, the judge found against us on each of the first 3, and as the court will have seen, in relation to practicalities, that was a matter which, if it had been voidable, he would have been open to hearing more submissions about, if and to the extent that the claimants had been able to identify another trustee, or if they hadn't, how that would ultimately play out. And the 2 matters which we bring before this court are the artificial tax scheme and the practicalities. For the reasons I've identified, the practicalities point only applies to the 2011 and the 2012 trusts, because they are presently without a trustee, inverted commas, whereas the 2014 trust does have a trustee who could take the assets back. And so we recognise that the practicalities point, if the court said voidable, is probably one where the court may well say, well, this should go back to the judge. And we're not going to independently make a decision about that, not least because where the claimants ultimately get to with the new trustee, still many years on, remains uncertain. And we obviously made various points as to why the claimants may have grave difficulties in getting a new trustee to take on these very problematic trusts. So I think the question in relation to the artificial tax scheme for this court is, should it be in play? Because the judge effectively, in terms, I'll come to this in a moment, said it's really just not a relevant consideration for the reasons he gave. Should it be back in play? Should this court say it's a sufficiently independent ground to refuse relief? Or in the alternative, this is our fallback position, we would invite the court to say it should be back in play before the judge when he's also dealing with the practicalities point.
That's a little odd, as he's already decided that he doesn't like it.
Yes, but if this court says he's proceeded on the wrong basis and it's a good point,
Okay.
he should. Obviously, that's our fallback position. Our primary position is this court should say that's a sufficient point.
Sufficient point for,
Refusal of relief if it's voidable.
so to allow the improper purpose.
Yes.
Yeah.
And the judge's reasoning, at which the court will have seen on this particular point, is 359 and 360. Paragraph numbers, and it's page 309 on the page numbers.
So this is on the artificial tax scheme.
Exactly. And I don't think, unless the court wants me to, I'm going to say anything else about the practicalities point.
No.
I hope we're being realistic about that as being a point for the judge, not for this court. So you'll see how the judge characterised the argument. That whether he said essentially, well, on the assumption this is 360, the schemes in the present case are properly described as artificial tax avoidance scheme which have gone wrong. He then essentially says, well, the claimants will be in no better position. They're not seeking to extricate themselves from their current tax position or breach any principle of public policy. And essentially, as we read it, he gave the point no weight at all. And we say that the judge approached that on an incorrect basis, a too narrow a basis, and should have given the fact it's a tax avoidance scheme weight in the exercise. And in support of that, my lady, we make 6 points, 6 headline points, with some hopefully not overly long development under each of those 6 points. My first point is that, as the judge said, it is clear this is an artificial tax avoidance scheme that has gone wrong. That was assumed to be the case by the judge, and I haven't seen that point being specifically argued against by my learned friends. But if I'm wrong about that, and there is points, my second point is there are particularly noteworthy features of the artificiality of this scheme. They were evident from the second structure chart that we attached to our skeleton. But the two main features were an insertion of new settler employees into an existing contractual structure for the sole purpose of avoiding tax by the claimants as the real, inverted commas, employees. And that these trusts evolved in a form which was designed to keep effectively avoiding the latest tax legislation, a sort of whack-a-mole type approach. And if the court would like some more detail about those points, you can see that in both of the first-tier tribunal decisions, which are in the bundle. I'm sure the court will find that helpful to look at that at all.
Well, I think you just give us those references.
Yes, so the 2019 decision of Judge Mosedale, and that's in Authorities Bundle 3, tab 43, page 814. And in particular, paragraphs 53, 218, and 286.
Thank you.
And there's effectively along the same lines in the 2022 decision of Judge Scott, Authorities 4, tab 47, page 1249, at paragraph 25. The other features were, of course, the use of the loans, which initially the claimants in their pleaded case did not accept were enforceable, but by way of amendment to their particulars of claim deleted that. And by the time we came to trial, it was common ground that the loans were enforceable on demand. And there's a curious feature of these schemes that it doesn't seem that anyone ever really had an idea as what ultimately would happen to the debts, which are the loans, how they would ultimately be appointed out, how they would ultimately be dealt with. And this fed into the problem that fees for the trust were up front, and that by the time you get to 2017, 2018, all the assets had gone, and no one had any money to deal with all the issues that arose. There was, we say, in the nature of the scheme, an inherent risk of failure in relation to income tax, which manifested itself through the loan charge, and also in relation to inheritance tax, and the particular problem that you only escape the inheritance tax regime under Section 86 if you had a genuine employment situation, which was not the case. And the consequences of all of these points unwinding is that a trustee would have to incur costs in dealing with the tax problems, but didn't have any assets. And so difficult to see how it could generate money to do so without either calling in the loans or seeking to realise the assets by way of sale or assignment. The third headline point is that, and I accept this is on the face of it, a different context, and I'll need to deal with that specifically. The courts have set themselves against allowing tax avoiders to escape the consequences of participation in artificial tax avoidance schemes. There's the well-known quote in Pitt and Holt about that, but what I propose to do is to take in a little bit more detail to the more recent case of this court in Bahor and Equity First Trustees, which is a decision of Lord Justice Snowden sitting with Lord Justice Arnold and Lewison. That is at Authorities 4, tab 53. I just give the court a little bit of background to that? It was a case concerning the equitable jurisdiction to set aside a voluntary disposition on the grounds of mistake in the context of a failed inheritance tax avoidance scheme. Marcus Smith at first instance had held it was not merely tax avoidance but evasion. And there was no relevant mistake when the entry into the EBT was made by the participants. He said it was a misprediction rather than a mistake. The appeal was dismissed, but the essential ground of the Court of Appeal was, well, even if it was a mistake rather than a misprediction, it would not be unconscionable or just to leave the scheme as it was, where the settler deliberately ran the risk it might not work. So effectively an assumption of risk point. And the Court of Appeal weren't prepared to uphold the judge below on the question of evasion. If I can then take you to paragraph 74, which is at page 1442. And the court will hopefully see, under the heading Mistakes About Tax, and the marked up passage, there's reference to a passage from Pitt and Holt and Law of Walker, which I alluded to earlier, which Lord Justice Snowden at 74 describes as an important passage. And perhaps the court just...
This is all under the heading Mistakes About Tax.
Absolutely. And at 75, the court referred to two first instance decisions where there had been some further discussion about this. Then moving on in the judgment. The point I made earlier as to the essential part of the decision, paragraph 101, which is page 1447, where the court said, you basically ran the risk, and if you run the risk, don't expect the court to help you out. Then the court then went on from 102 through to 106 to say, deal with the artificial tax avoidance points. And perhaps I can invite the court to cast its collective eye over those paragraphs. So in that case, it was an EBT without any employees, or at least not any who were intended to benefit from the scheme, and was thus described as artificial, indeed difficult to imagine a more artificial construct, as the judge said it at 104. The trust had no independent business or commercial purpose and brought into existence an estate transferred to it by the transfer of shares purely and simply for the purpose of tax avoidance. At least when looking at the schemes, whilst there's differences, of course, in fact, between the scheme here and here, the present case, the only purpose of having the settlement and the trustee as the employer was to seek to avoid tax in exactly the same ultimate fashion. 105, Lord Justice Stone said, I fully accept that tax avoidance is not unlawful. I agreed Lord Walker's observation, artificial tax avoidance is a social evil, but it's an unfair burden on the shoulders of those who do not adopt the measures. In my view, this is a very weighty factor against the grant of relief. And he then refers at 106 to it not being unjust or unconscionable to refuse equitable relief. So my fourth point, which is picking up on what I said towards the start by reference to Rice and Rice, is, before coming to the differences, this is the exercise the court is engaged in avoidable situation. It has equities, different equities, the equity of the beneficiaries to set aside the voidable claim of my client to the asset, and it has to weigh those up and decide where ultimately justice lies. And the exercise in principle in my submission, whether it's unjust or unconscionable to refuse equitable relief, is not different in the situation before the Court of Appeal in Bahur and the present case. In terms of the nature of the exercise. But this is my fifth point. We obviously have to recognise a factual difference, which is...
I've lost a point, I'm sorry. So your fourth point was?
Back to the Rice and Rice.
Yeah.
Overall, unjust and unconscionable, where do the equities lie point. Broad equitable discretion. And then fifth point, we recognise the factual distinction between cases such as Bahur, where it was about relief from the scheme structure itself, and the present case where the claimants say they just want the scheme structure to be restored. But we submit that's not a critical difference to tax relief at least being a matter properly for the court to consider, rather than simply dismissing it as the judge did. And equally, we recognise that in Bahur, the court was weighing up the mistake, assume there was a mistake, as against involvement in tax avoidance. Here, you're weighing up taking an asset with notice of improper purpose as against the artificial tax scheme. And on the facts, that may or may not lead to different outcomes, but nevertheless, it's still an exercise the court should engage in. And this is just still under my fifth heading. Although the judge held they were not trying to avoid the fiscal consequences of the scheme, we submit there shouldn't be a sharp dividing line between fiscal and non-fiscal consequences. And the court is entitled to look at it more broadly. And what's really going on here? Well, the claimants obviously consider there is some tax advantage or some...
Can you say that? Do we know that? Is there any evidence about that? Isn't that a little bit far, Mr. Morgan?
Or some financial advantage. They want the scheme to be restored. Now,
and you don't. So there must be some financial advantage somewhere, otherwise we wouldn't be all here.
That is true. But
290 million, 420 million, some eye-watering sums knocking about for the valuation of this.
yes. But what they wish to do is to take some advantage. We don't know precisely what it is. We don't know what their motivations are. To take advantage of what we've described as an artificial tax scheme. And in our submission, that falls within the social evil described by Lord Justice Snowden at 105. And in some ways, seeking to take advantage of the scheme rather than to be extracted from it is at least as objectionable in these circumstances. And what we say is if tax avoidance is a social evil, when a tax avoider comes to court with sort of effectively complains about what's happened, it's open to the court to weigh that in the balance and decide whether or not to grant relief. And as I think I've said, the danger of repetition, the judge effectively, we say, struck it out as being not a consideration, whereas it should be a consideration. And then sixth, and this
So if
is...
the judge had said, well, it's a consideration, but in the circumstances it has minimal weight, you'd be happy with that?
Well,
or at least, put it another way, he would not have made any error.
that would be a more difficult situation for me, but in circumstances where, if I'm right, he's effectively made an error of law in excluding it from consideration, then I have at least the advantage of being able to say, if the court's with me on that, that this court can exercise that discretion afresh rather than being subject to the usual parameters of such a challenge. And then six, this is got some subpoints, but is my final point. It's essentially the balancing exercise. What the claimants say is hardship to them, which outweighs any interest that we may have. What do they say? Well, we say that the loans were repayable regardless of who holds title to them. They initially sought to quibble about that, but by the time we got to the end of the trial, it was agreed that the loans were enforceable obligations. I've already made the point that the failure of the schemes and problems which have manifested themselves would have been likely to lead to real possibility of the trustee calling in the loans in order to provide some funding to deal with the situation that has arisen. Now, except that what we now have is a structure which is outside the original trust structure. So essentially, there's a liability for the loans, but without the possibility of reappointment or reimbursement through the trust structure. But where ultimately that will lie financially is unknown. The judge wasn't able to make any findings about the balance sheet position. Ultimately, what payments, if any, will be made in relation to the loans. Ultimately, what a new trustee will do. Ultimately, how this will all play out. So the prejudice to the claimants is not known. The prejudice to my client so far is it's paid £100,000, and if it goes back, it's got nothing. So that's clearly identifiable. And picking up on my Lord Justice Coulson's point, I can see that 100,000 is a small figure compared to 270 or 420. But those, as the judge said, he could make no findings about what was ultimately going to be recovered as a result of this. So ultimately, we submit this is a case where the court can properly say, you've involved yourself in an artificial tax avoidance scheme. It's gone wrong in an entirely predictable way. That has resulted in attempts of realisation. And in those circumstances, it would be inequitable to allow you to have the structure restored for obviously some form of advantage that you perceive. And that would run counter to public policy. And that's a decision to say this court we invite it to make, or if not, to direct the judge, and it goes back to him when he's also considering the practicalities point, which does seem to be a very real point that he was himself alive to.
So not so much a case of balancing the beneficiary's interests against yours as where balancing their interests against public policy considerations. I mean, as a trustee who's acted for an improper purpose, you're not in a very strong position to invoke public policy in your favour.
Yes, I wasn't the trustee acting for an improper purpose, though I had notice of it on the judge's findings. But your lordship is quite right to put it as in that nuanced way. If the consequences of that are that my client keeps the assets, well, that's the consequence of the application of the public policy and the social evil that is described as in relation to avoidance tax schemes. I intended to take half an hour. I think I've just about managed that. Those are the submissions I wanted to make on that issue, unless I can assist the court any further.
Can I ask a question about the practicalities
Yes.
or otherwise of the appointment of other trustees? I'm just I wonder whether you know whether there is such a thing as a judicial trustee in Jersey.
The other side have referred to potentially making an application
Yeah.
to the court in Jersey. What steps they propose to take in that, I don't know.
Okay, thank you.
Yes, just wondering, again in practical terms, the extent to which ground 3 is going to make a difference if we were to be against you on ground 4. So, in other words, the order that the judge actually made doesn't look very different from the order which he would have made if he'd gone down the voidable route. Can you help about that?
Yes, well, I think our reading of the judgment is that even leaving aside the tax avoidance point, if the judge had concluded it was voidable, he would have wanted to hear more argument on the practicalities point. And if I could take the court to the judgment at paragraphs 368 and 369, which is at page 310. The bottom of 310. 367, he identifies our fourth point, and he starts at 368 to outline my appropriately measured submissions, as he put it. And then at 369, he expressed the view that there was some merit in this particular objection to the court setting aside the disposal. And he was conscious of the fact that the argument at trial only touched upon it. And he said it wasn't clear if there was appointment of new trustee would have been feasible.
Yes, well, in other words, as I read it anyway, tell me if I've got this wrong. If we can't get a new trustee, then there's no point in setting it
Yes.
aside. But if we can get a new trustee, then he would, on the voidable hypothesis, having rejected your other arguments, set it aside. And then he would have made the same order as he did in fact make, which is to transfer the assets to a new trustee once one is in place. So, although ground 3 was frightfully interesting, I'm just wondering if we were to be against you on ground 4, whether in fact they lead to the same ultimate route. That is to say, if you get a new trustee, you would have to restore the assets. If you can't get a new trustee, then the order which the judge made is never going to come into force anyway.
In relation to the 2011 and the 2012 trusts.
Yes, well, we don't. Well,
The 2014,
worry about 2014, do we?
although that could in isolation be affected by the tax avoidance point without the practicalities
Yes.
point. But subject
I mean, I mean, if we're with you on tax avoidance, then we don't get this far. I'm just wondering if we were to uphold the judge on that, whether ground 3 actually makes any difference at all.
yes, I mean, I can say this. Paragraph 372, the judge said, I would be required to hear further argument on what I should do given the apparent absence of anyone available to act as the trustee. And as the court has seen, we've put forward a whole load of reasons as to why a new trustee is going to find this a particularly unappealing prospect. And at the moment, nothing's been presented to us from the claimants as a sort of neat solution to this. So whilst in theory, I think I understand.
But the order the judge made only takes effect on you receiving notice of appointment of a new trustee. So if there never is a new trustee, because the practicalities are insurmountable, effectively you've won.
Yes, but we could be in suspense for 10 or 20 years. Whereas if in fact it's the position, I think we're still subject to an undertaking. Whereas if in fact this is not going to be resolved for a long period of time, that's sort of acceptable. We should be able to deal with the assets. In other words, we would say the judge needs to bring it to a head by making a final decision one way or the other as to whether or not, in fact, there is a new trustee and he's going to do it. Two separate questions, possibly, or whether there isn't. And it's not appropriate to leave that hanging there because we can't do anything with the assets for indefinite period.
Yes, all right, thank you very much.
Unless I can assist any further.
Thank you very much indeed, Mr. Morgan. And we've done well for time.
Lady, my lord, I appear for Pinotage on a separate appeal, which is confined to the Head and Gould retirement to facilitate breach of trust. In the rather circular way of this case, this, of course, only matters if and to the extent that the loans do not. The trusts do not get reconstituted because it only goes to our personal liability insofar as that has not already been met. I'm conscious, my lady, my lords, that I too have to make an appeal against the finding of fact, and I think it's important that we go first to what exactly the finding of fact I'm concerned about is. In the judgment at paragraph 394, which is at the top of page 318 in the core bundle, tab 16. So we have paragraph 394, to which I make no objection in light of all the other findings, which is to the effect that at the time of the transfer from my client to the PTC, everyone intended that matters would go on as they were and my client would continue to have administrative, do back office functions. The point where I start finding objections is paragraph 395. Returning to my argument, it is true, as I have said, that the second defendant retired as trustee by reason of its regulatory concerns. This is an incomplete statement. And then the fourth line down in that paragraph, the whole purpose of putting Pinotage PTC in place as new trustee was to allow the sale of the loan assets on terms which excluded the interests of the beneficiaries to proceed to completion. And then the penultimate sentence of that paragraph, put more simply, Pinotage PTC was put in place as trustee in order to ensure that the disposal would proceed and would not be frustrated by the second defendant's regulatory concerns. And it's those sentences that I've picked out which I say don't follow from any of the evidence before the learned judge and don't follow from what he said in the preceding paragraphs of his judgment. We then, before we leave this bit, we get paragraph 396. First sentence, again, I can't complain of. These facts also seem to demonstrate the second defendant contemplated the very breach of trust which was committed at the time the second defendant resigned. But the next sentence, again, these facts seem also to me to demonstrate, and I so find, that the second defendant retired in order to facilitate the breach of trust which was committed, namely the disposal. That follows from the sentences I've picked up on in paragraph 395. Now, if we could now go back in the narrative section of the judgment to paragraph 82, which is on page 238. So paragraph 82 is where this issue first appears in the narrative. In the meantime, the second defendant was becoming concerned as to its own position. And then the judge sets out, in the next couple of paragraphs, quotes from a lengthy file note, which was in evidence. It is in the supplementary bundle. I'll give you the reference, but I don't think we actually need to go to it because everything material is here. It's tab 4, page 206 in the supplementary bundle. So, Lady Mullers, I'll just pick up a few points from that file note. This non-compliance of the beneficiaries providing KYC causes Pinotage to be in the unfortunate position of not being able to comply with the directives of ARIF from a regulatory and compliance perspective.
I'm not sure where you were reading from then.
I'm reading from paragraph 83 of the judgment, which is itself quoting the file note.
Thank you. Second paragraph, many beneficiaries have failed to respond.
That's correct, yes.
Thank you.
By way of illumination, what was teased out in cross-examination of Mr. O'Shea was that although it's not absolutely necessary to have KYC on every one of thousands of possible potential beneficiaries, it is, he said, necessary to have KYC for beneficiaries to whom you have lent money or to whom there are loans outstanding. In paragraph 82, at the start of that file note, we have non-compliance with the directives can result in monetary penalties and may lead to ARIF revoking Pinotage's membership. The evidence on this point was in the first witness statement of Mr. O'Shea, which is in Core Bundle 2, and the relevant part of that witness statement is on page 520, starting at paragraph 43.
I'm sorry, I'm going to have to give me a moment.
So what was the reference again? File reference?
The Core Bundle 2, it's the first witness statement of Carl O'Shea. It's page 520, starting at paragraph 43.
Order 29.
Generally.
Yep.
So he talks there about the sanctions of for non-compliance. Paragraph 45, a fine of up to 500,000 Swiss francs over the page and exclusion from ARIF. The second defendant considered it probable it would lose its license, suffer penalties and fines if the approaching audit was negative. Mr. O'Shea was cross-examined by Mr. Mile for a considerable period of time, over I think 3 days. And the transcript of that cross-examination is in the supplementary bundle. I don't propose to take you to it right now, although I can give you the relevant page references if that's helpful. I think they're also in my skeleton argument. Because the point is that in my submission, nowhere in that cross-examination is there any suggestion that this regulatory audit was going to cause problems for any sale of the loan book, of the trust assets. The problems were going to be for Pinotage as a business, not for the proposed transaction. And it's for that reason that we say, if we go back to the, we could go first to page 315. This is back in the judgment in the core bundle. Who would like to do that?
Paragraph, please.
Sorry, my computer was not cooperating well. Paragraph 386 on page 315 of the core bundle.
Okay.
At this point, this argument, i.e. the argument that I had put forward, that perhaps we should look at the previous paragraph, 385. It must be shown that the breach of trust was contemplated by the original trustee when the retirement and appointment took place. It must be shown that the second defendant retired in order for the breach of trust constituted by the disposal to be committed by Pinotage PTC. On the facts of the present case, it was submitted the retirement of the second defendant had nothing to do with facilitating any breach of trust, but was the result of the problems with obtaining KYC and the associated concerns for the position of the second defendant in relation to the Swiss regulatory authority. And it's that argument that over the page he says, at first sight, this argument appears to be well-founded. It is perfectly true that the second defendant resigned from its position as trustee by reason of regulatory concerns. He talks about the evidence of Mr. O'Shea and the contemporaneous documents. The email from Mr. O'Shea is in the supplement. Yes. There are several emails, I was looking at the wrong one. The email from Mr. O'Shea that's referred to in the judgment there is in the supplementary bundle at page 221. I don't need to take you to it.
It's the one at paragraph 84, isn't it, of the judgment?
Yes, yes. But what the learned judge seems to conclude by the time he's got to paragraph 395 on...
Well, he said that that's not the whole story.
That's not the whole story.
He says 387, he says that's only part of the story.
That's only part of the story, yes.
And then he goes on to deal with other parts of the story. And then we come to which paragraph?
To paragraph 395 on page 318, which is where we started.
Yeah.
The whole purpose of putting in Pinotage PTC in place as new trustee was to allow the sale of the loan assets. Well, nothing that he said in the previous paragraphs and none of the evidence that he's looked at justifies that for the whole purpose. and none of it justifies what he says in the penultimate sentence. Pinotage PTC was put in place as trustee in order to ensure that the disposal would proceed. Because he hasn't indicated anywhere that any finding that there was any real risk of the disposal not proceeding, rather than of Pinotage being in trouble with its regulator, auditor. Lady and Lords, in my submission, this is a distinction which matters on the relatively few authorities that exist on this point. So, if we could go to the authorities bundle, the first, I think all of my authorities will be in the first authorities bundle.
Before we do that, though, haven't we missed out a step in the judge's reasoning? Because you've taken us from 385 or so and 6, and then straight on to 395 and 6 and 7. But he gives examples of what he says is the whole structure of the deal, put it that way, from 389 right through, and quotes quite a lot of cross-examination right through to when he gets to 394.
Yes.
And it's that whole picture which gets him to where he is in 395 and 396, isn't it?
Well, in my submission, it doesn't get him there.
Well, yes, but we haven't teased it out to see whether it does or it doesn't.
In that case, if we could go back in that case to...
I'm just concerned that I've missed out a link in your chain.
So if we go back to 390...
Well, at 388 he says it's all very different, and he talks about the failure of the Pyrrhus scheme and being the second defendant being retained in an administrative role, etc. And then he gives examples of that being the case, that it was still in the mix, let's put it that way, and intended to be in the mix. And then his first example is at 390, and that's about was PTC still going to be doing admin, and then more of that at 391. But then there's a discussion, for example, at 392 in the extract, in the second paragraph, to the sale of the debt book is a fait accompli, so the beneficiaries need to be informed, etc., etc. So what he's doing, and query, is saying this was all part of a scheme to make sure that we could terminate the trusts because there'd be no money left, and it was all one and a whole. So where does he go wrong?
Because nowhere in that scheme, as he describes it, is there mention of a step being, and Pinotage had to retire in favour of the PTC for this to happen.
Okay.
But isn't that a bit artificial in respect? I mean, if you look at 396, which is the last bit, you don't quibble with the first sentence. That's the finding of fact, or finding of facts as he's gone through. And he says, second sentence, these facts also seem to me to demonstrate, and I so find. So from all of that, he draws that inference. He's quite entitled to do that. He heard this for 8 days.
I say that in the previous paragraph there is nothing that entitles him to draw the second inference retired in order to facilitate the breach of trust, and those are two distinct limbs of the head and gold test that the trustee both must retire in order that the breach of trust can occur, and that the particular breach of trust that occurs is one that was already in the previous trustee's mind.
Yeah, well, okay. I mean, I think that's the territory that we're in.
So,
Okay.
but that was my answer to Milady's question.
Yeah.
There, nowhere in those paragraphs is the replacement of pinotage by PTC a necessary or even particularly helpful step in carrying on with the disposals. It's directed purely towards Pinotage's own concerns as a business. And if we look at the old cases, almost all of them are in fact concerned with situations where the test was not met. The very first one is Webster and Hunt, which is tab 7 of the authorities bundle, but that says almost nothing beyond a bare statement of principle. It's sidelined on page 34 of the authorities bundle.
I'm sorry, I think you said a little earlier that all authorities are going to be in the first volume. So
I'm not absolutely sure about the last
No.
one, but that's the only one that I might be wrong about. I'm using
I
electronic.
won't hold you to it.
I was going to say, we didn't take it as a guarantee. Mr.
No, I'm not looking at it unless it's in the first volume.
Even that one doesn't really. So.
Okay, so we were at 7, which is Webster.
Webster, it's a bare statement of principle. You can't derive much from it, and it's dealt with later on in head itself. So
Okay.
I was going to pass on to Palere and Carew, which is tab 9. Page 47 for those.
Yes.
Mr. Carew was a trustee who was asked to, by his beneficiaries, to carry out what seems to be a perfectly ordinary sale and made everybody's life difficult. And the reason he insisted on various documents he wasn't entitled to. And on page 48 of the bundle, towards the bottom, it should be sidelined. We see Mr. Carew's argument. He declined to do this, i.e. retire, without seeing all the documents and papers relating to the other trusts, upon the grounds that if a trustee surrendered up a trust to a person who committed a breach of trust, he might be liable. That no doubt is correct to this extent. If a trustee be called upon to commit a breach of trust and refuses, and his custody trust say, there is AB who will you resign and surrender to him? And the old trustee accedes to that proposal and transfers the property for the purpose of enabling him to commit a breach of trust. In that case, the old trustee would probably be visited very severely by the court. And that is, of course, the paradigm example, is the one that you get taught on when you're learning law. So if you are asked to carry out a breach and you say no, but I'll step down and somebody else can do it if you like, that's not going to save you. But that is not our case, because in my submission that is not why my client stepped down as trustee. The next authority, or pair of authorities, really are the Clark and Hoskins decisions.
Where are they?
They are tabs 12. Tabs 12 is the first instance decision before the Vice-Chancellor Stewart. Mrs. Brown was the settlor and life tenant of a marriage settlement, and she wanted to, as with some of the cases Mr. Lewison took you to earlier, raise some money, free some capital. So she went to her lawyer, who first of all suggested that maybe the settlement was void anyway, invalid and a nullity, and that she should raise money by mortgage of the property as though she were the absolute owner. And then she went to her trustees, Mr. Joburns and Mr. Hellier, and said, will you help me? And they said, no. But after some discussion, they agreed to retire and appoint new trustees. And the story then goes on for quite some time, but it seems that the new trustees then assisted in suppressing any evidence of the settlement so that Mrs. Brown could go and mortgage her leaseholds. When the judgment of the Vice-Chancellor was, which is at page 68 of the relevant part is page 68 of the bundle. It should be sidelined, and it's the sidelining on the right with which I'm concerned. I don't think I need to look at the place on there. Where a trustee entrusted with property for the benefit of others resigns the trusteeship after he's been requested to deal improperly with the property, and after he has refused to comply with that request because he knew that to have acceded to it would have been to commit a breach of trust, he is placed in a position of gravest peril. And the reason of that is this: if a trustee to whom the commission of a breach of trust is suggested declines to commit it himself, but does that which enables another to commit the act, it is but doing it through the agency of the person to whom he assigns the property. So the Vice-Chancellor found that the original two trustees were liable. However, the Court of Appeal disagreed. And this is the next tab, tab 13.
We had a low woman without fortune this morning. We have a mere working carpenter this afternoon. There's a certain flavour to some of these cases.
And the relevant bit here is page 77 of the bundle, sidelining on the right in blue. I conceive it would go far beyond anything which has ever been done in this court to fix these gentlemen with the consequences, when it was not in their contemplation that such a fraud was to be perpetrated, i.e. suppression of the mortgages completely, but it was in their contemplation simply that a sum was to be raised as against Sesquique Trust, which would be improper for the trustees in the execution of their duty to raise. Now, I understand that Lady Milords is saying that they were worried that it would be a breach of trust because it would be a foolish thing to do, not that it would be a breach of trust because they were being asked to hide any evidence of these mortgages of the trust entirely. So my point again is that the extent of this potential liability is being ultimately cut down by the court. It only applies in quite narrow circumstances. The paradigm example of which being the ones referred to in Palero and Carew. I won't do the trust, but I won't do the breach, but I'm quite happy for somebody else to be appointed and they can do it. And then finally we come to Head and Gould, which is tab 16. And if we could perhaps start with a head note at the... Yes, if we start with the head note on page 94. And it's the first bit of the head note that I'm interested in. To make a retiring trustee liable for a breach of trust committed by his successor, it must be proved that the very breach of trust which was in fact committed was not merely the outcome of or rendered easy by the retirement and new appointment, but was contemplated by the former trustee when the retirement and appointment took place. Now, in my submission, that paragraph from the head note is an accurate rendition of what Head and Gould decided on this point. And the point I want to draw from it is that those are two necessary limbs. The breach of trust must be both the outcome of and rendered easy by the retirement and appointment. That's what everyone had assumed. And also must be something that was contemplated by the former trustee when the retirement and appointment took place. And yes, page 112 is where Mr. Justice Kekowicz is setting out what is being put against the old trustees. You were urgently pressed to make further advances to Mrs. and Miss Head. This is a marriage settlement again. And you asserted with perfect truth that no further advances could properly be made. That is, could not be made at all without a breach of trust far more serious in fact and in its consequences than any that had yet been committed. In order to relieve yourself and to directly assist Mrs. and Miss Head, you suggested, or if you did not suggest, assented to, the appointment of new trustees who you knew would be more accommodating and contemplated, if they did not actually intend, that which you had properly declined to do. That's not a finding, that's Mr. Justice Kekowicz putting the case. I have no doubt that if this charge can be regarded as proved, the responsibility insisted on must follow. but he found it was not. If we go down to page 117, is where he's looking at Clark and Hoskins. This is the foot of page 117 and over to page 118. With the judgment of the Court of Appeal in Clark and Hoskins before us, it is easy to understand the master of the rolls as meaning what he probably intended to express. That in order to make a retiring trustee liable for a breach of trust committed by his successor, you must show clearly that the very breach of trust which was in fact committed was not merely the outcome of the retirement and new appointment, but was contemplated by the former trustee when such retirement and appointment took place. Well, that second limb was not met in Head and Gould as it had not been met in Clark and Hoskins. We concede that it is met in this case. The transaction which has been found to be an improper purpose was contemplated at that time. But in my submission, the authority derived from these cases is that the retirement and replacement must be causative. It must be so that the breach of trust will in fact take place. And my submission is that the finding that that was the case in our case rested on no proper foundation. My lady, my lords, in my skeleton, I pointed out that there's actually very little authority following this, and very little of it is particularly interesting or helpful. The only one I did want to look at briefly is tab 20. This is the one authority I'm not absolutely sure is in the first volume.
It is. Curtis.
Curtis Furnishing Stores. The headline point from Curtis Furnishing Stores is that the principle is applied to company directors. And the relevant quote is at page 163 of the bundle. Between D and E on page 163 of the bundle. If a director who's about to retire and sell his shares makes a bargain with his intended successors and the purchasers of his shares, that when they are in control of the company, they will procure it to make a present to him out of its assets, and this is done, the recipient is, in my judgment, as guilty of misfeasance as the directors who actually procure the company to make the gift. But in my submission, that's not a particularly surprising finding. But again, it is a causative step. I will retire as company director. You will come in and quid pro quo. You will procure that I get a present out of the company's assets. Again, there is a causative step as well as it being in mind before the retirement, and there is a causative element in the retirement and replacement and the breach, as well as it the specific breach being in mind at the material time. So, my lady, my lords, the case against us is that we have personal liability for breach of trust, and we must compensate the trust fund to an amount to be quantified at some later hearing should the point ever arise. But in relation to these two trusts, the 2011 and 2012 trusts, we were not the trustee, and we can only be personally liable. We say we were only still fiduciaries in respect of those trusts under the principle in head and gold. And we say that that is not met because our retirement and replacement by the PTC was entirely orthogonal to the proposed or contemplated disposal of the trust assets. There is nothing to support a finding that it happened in order that that disposal to take place. It's not even clear how it could possibly have even assisted in that transaction taking place. And we say, unless you have both those elements, the breach being in contemplation and the causative element, then the liability of Head and Gould does not follow, as it did not, for different reasons, in each of the older cases at which we lived. So those are my submissions, my lady, my lords, unless I can insist on anything.
Thank you very much indeed. Mr. Mayor.
My lady, my lords, I'm grateful. Just permit me just a couple of moments to rearrange the boxes.
And me too.
I'm grateful. My lady, my lords, I propose, subject to any direction you give me, to deal with grounds 1 and 2 together because they are very closely related and because we consider that both of them are answered comprehensively by one or both of two particular points. And in our view, grounds 1 and 2 of the first appellant's appeal essentially form the contention that the judge should have found that the bona fide purchase of defence was made out, and that the first appellant is therefore entitled to keep the loan assets that were transferred to it under the disposal. Now, the starting point for that contention in our submission has to be the unchallenged findings of fact made by the judge, because those are the four corners in which this appeal must be argued, and in which the first appellant's contention must be judged. What I propose to do is just summarise what we say are the key unchallenged findings. For your note, I wasn't going to take you back to it yet again, but we can obviously look at the judgment in due course, or now if we need to. They are in paragraphs 297 to 299 and 305 of the judgment. There's also findings at 303 which I'll come on to in terms of what the evidence showed or didn't show. And those are at core bundle pages 291 to 294 in the first volume. In summary, the key unchallenged findings are as follows. Firstly, that the first appellant's directors, Mr. Emden and Mr. Reed, designed the disposal in concert with the trustee. That is obviously not disputed. The second finding is that they knew that the loan assets could have substantial value. The third is that they knew there was a real possibility that the beneficiaries had an economic interest in the trusts. the fourth is that they knew that the purpose of the way in which the transaction was designed was to ensure that there would be no surplus remaining for those beneficiaries. The fifth, which follows from that, is that they knew, therefore, that the interests of the beneficiaries were being deliberately disregarded. And the final one is that neither Mr. Emblin nor Mr. Reed was satisfied that it was legitimate to disregard the interests of the beneficiaries in that way. So we say that provides the parameters, the unchallenged factual context in which the appeal is brought. Notwithstanding all of that, my learned friend says, the judge should have found that Mr. Emblin and Mr. Reed did not know that the transaction was a breach of trust as a matter of strict Jersey law, and that they can therefore rely on the bona fide purchaser defence. Now, my lady, my lords, we say that is wrong for two reasons, and they are essentially the two reasons the judge gave. The first is that the evidence given by Mr. Emblin and Mr. Reed was not that they were unaware that the facts, as alleged, amounted to a breach of trust as a matter of Jersey law. That was...
Sorry, could you repeat that?
Yes, of course.
Their defence was...
Their evidence, the evidence they gave was not that they were unaware that the facts, as alleged, amounted to a breach of trust as a matter of Jersey law. So that wasn't the case that they were advancing. Or to put it a different way, that's not the way their case on knowledge was presented. The submission that they did not know that the transaction amounted to a breach of trust as a matter of Jersey law, we say was essentially a pivot made in closing argument by my learned friend after it had become obvious that Mr. Emblin and Mr. Reed had intimate knowledge of the transaction and the way in which it was designed. So that's the first point. The second, we say, is that in light of the factual findings that the judge made, and which are unchallenged, we say there is no room for a finding that the first appellant did not know that the disposal was a breach of trust as a matter of Jersey law. And I'll explain that in a little bit more detail, but in summary, the judge found that Mr. Emblin and Mr. Reed were not satisfied that it was legitimate.
Sorry.
I beg your pardon, my lady.
No, I'm sorry, I'm being slow. The factual findings leave no room for a finding that they didn't know that there was a breach of trust under Jersey law.
Indeed.
Yeah.
And in summary, that is because the judge found that Messrs. Emblin and Reed were not satisfied that it was legitimate to disregard the interests of the beneficiaries. And we say it is a distinction without a difference. Indeed, my own friends seem to accept this point. I'll develop it early, in a short while. But it's a distinction without a difference that they are to say that they were nonetheless not aware of the technical Jersey law position. And this comes back, and I'll develop it, comes back to the phrase probably improper that one sees in Sinclair and the use of impropriety that one sees in some of the other cases. But essentially the point is the judge had found, I don't want to go out of order in my submissions, but the judge found not simply that they knew the facts, but that they were not satisfied that it was legitimate to disregard the interests of the beneficiaries. So I'll deal with each of those arguments in more detail in turn, and then I will address the further point raised by our respondent's notice in relation to the standard of knowledge which it fell to Minoda Friends' clients to show that they did not have. I'm going to start with lack of evidential foundation. The reason I start there and with the burden of proof is because of its importance in this case. Excuse me. The parties agree that the burden was on the first appellant to prove that it did not have notice of the breach of trust. I don't need to take you to any authority because the proposition is not in dispute, but for your note, in case you want to look at it, see the Court of Appeal in Barclays Bank and Balta, which is in the authorities bundle, first volume, tab 24, at page 278. And it's a passage in the judgment of Lord Justice Mummery. But it's a well-established principle, and it's not in dispute in this case. The reason why it is important in my submission is not because the burden of proof was being used by the judge as a tool to resolve an evidential uncertainty or as a sort of technical tie-break, which is what Malone and Friends suggests in his skeleton by reference to the Verlander case. That is not what the judge was doing in this case. The burden is important because it tells you that the question of the first appellant's knowledge is an ingredient of their defence of bona fide purchaser and not an ingredient of the respondent's cause of action. And it follows from that that if the first appellant wished to argue, of course, that the reason it did not have notice of the breach of trust was because its directors did not know some feature of Jersey law, then it needed to identify that, and it needed to adduce evidence from its directors to prove that case. And in simple terms, we say it simply didn't do so. Importantly, or most importantly, well, we say the case was not pleaded in relation to Jersey law on the question of the director's knowledge. The question about insolvency of Jersey law was an issue in the case because of the question of whether the transaction was improper, as in whether the purpose was improper, and the insolvency point. But on the question of knowledge, that was different. But the most important feature in my submission is that Mr. Emblin and Reed did not put their case that way at trial. Because it doesn't, in some ways, matter so much what the pleading position was, but more what the evidence was. Now, the court has their trial witness statements. They're at tabs 30 and 31 of the core bundle, volume 2. At pages 530 and 544. And nowhere in those statements will you find the contention that Mr. Emblin or Mr. Reed believed that under Jersey law it was permissible to disregard the interests of the beneficiaries. Instead, what Mr. Emblin and Mr. Reed sought to do in their evidence was to create an impression, or to deal with the issue of notice by seeking to create the impression, that the disposal was the outcome of a commercial negotiation, and that they didn't know how the cap on the deferred consideration had been calculated by the trustee or what its purpose was. Now, my lady, my lords, my learned friend didn't take you to the witness statements. I'm sure you'll either have read them or you will read them when considering this case. I don't know whether it would help if I can take you to show you what the directors did say, insofar as it would be showing you that they didn't say that. But my learned friend didn't seem to actually rely on anything in the evidence and seemed to accept that there was no evidence given by them on this point. So whether it's strictly necessary, but I'm obviously guided by you as to whether you want to look at them.
I don't think so, thank you.
Well, I've given you the references in case you need to see them. So the case, therefore, that the first appellant put forward in its evidence in chief at trial on notice was nothing to do with knowledge of Jersey law. It was that the disposal was this arm's length negotiation, a commercial case with a commercial price. And that case was rejected by the judge, who found that Mr. Emblin, Mr. Reed and Mr. O'Shea had acted in concert with one another in designing the transaction so that the creditors, Mr. O'Shea's entities, would be paid, and so that the beneficiaries would be left with nothing, whilst also allowing the first appellant to profit from what they knew could be very valuable assets indeed. And as I say, the submission that's now being made concerning Mr. Reed and Mr. M's belief at the time was not supported by evidence and was an argument made in closings in light of the cross-examination. So we say the judge was right to conclude, as he did, that that was not how the evidence of Mr. Emblin and Mr. Reed had been presented, and that they simply hadn't established on the evidence that they were ignorant that the transaction was a breach of trust as a matter of Jersey law. So if you're with me so far in the argument, where I get to now is what my learned friend now tried to point to. And what he tries to point to and argue is that there was an evidential foundation, albeit tellingly not one based upon the witness statements of his client's directors, which seems rather fatal given that the question is what the subjective knowledge of those individuals were. But he instead points to Z trusts, so one Jersey case, Z trusts, and 2 emails sent by Mr. O'Shea, which I will deal with separately. So I'm going to move on to Z trusts, which you've seen already. And Z trusts is in the authorities bundle. It's authorities bundle 2 at tab 37, page 753. The key point, my lady, my lords, that I want to make about this before we look into the case is, of course, that there is no evidence that Mr. Emblin or Mr. Reed were even aware of the existence of this case. They don't mention it in their witness statements, it's not referred to in the documents. And for that reason, we say it is irrelevant to the question or the issue of what they had in mind at the time of the transaction. And the argument about Z Trust at trial was in respect of the question of whether the purpose of the transaction was improper as a matter of Jersey law, not the question of what Mr. Emblin and Mr. Reed were thinking about at the time. And secondly, although we say it's simply not relevant for that reason, we say it's wrong to say that Z Trust was ever authority for the principle which Malone seeks to derive from it, that where a trust is cash flow insolvent, the economic interests of the beneficiaries can be entirely disregarded and only the creditor's interests can be considered. We say that's not correct and that the judge did not find that that was ever the position as a matter of Jersey law, as Malone and Friends suggests. If we turn up then Z Trusts. As Malone and Friends said, this was a first instance decision of the Royal Court, and the settler of the trust, Madame C, had exercised the power to appoint 2 additional trustees to the trust. And the question was whether this was a valid exercise, and in particular whether it had been exercised in the interests of the beneficiaries or the interests of the creditors. And if we turn down to 763, we come to the passages on which Malone and Friend turned earlier in his submissions. And at paragraph 28, the court says, although not canvassed at the hearing, we should make it clear that in the context of a trust, we consider the test for insolvency to be the cash flow test. So just point out, just pausing there, that in fact it doesn't seem to have been the issue of any argument before the court there about whether it should be the cash flow or the balance sheet test in a particular situation. But be that as it may, they say, the Royal Court says they consider the test for insolvency in this context to be cash flow. And then the judgment refers to a case called Del Amo. And Del Amo, as I think Malone Friend said, was an insolvent estates case, where it was said ultimately that actually in the insolvent estates context, a balance sheet test is applied. But the Royal Court concluded at 29 of this judgment that a trust is more akin to a company or an individual in the course of its business than the winding up of an estate, and so therefore the cash flow test should apply. And then if one moves down to paragraph 30, the Royal Court says, as stated in paragraphs 24 and 28 of Del Amo, so it's taking from a balance sheet insolvency case, a principle that in relation to estates, insolvency brings about a shift towards the interests of the creditors, analogous to that seen in company law. And a trust that becomes insolvent should thereafter be administered on the basis that it is insolvent, treating the creditors rather than the beneficiaries as the persons with the economic interest in the trust. As a matter of logic and principle, it's difficult to see how else an insolvent trust should be administered by the trustee and supervised by the court. And then Malone Friend, I think, referred to paragraph 32 and the first sentence that is said there. As Malone Friend said to you, they tried to take from this the principle that as soon as there is a cash flow insolvency, the interests of the beneficiaries can be entirely disregarded. And in our submission, we say it's obvious that that proposition would be wrong. We've given the example in our skeleton. I think my lady referred to something similar this morning, that if the trust's only asset is a Picasso worth 100 million, and it has no liquid assets, and there's a £100 storage fee or £10,000 cleaning fee or whatever it might be, some relatively modest liability, the trust is obviously cash flow insolvent. But the trustee would, we say, obviously not be entitled to disregard the residual economic interests of the beneficiaries in the trust and sell the painting for the sum due to the creditor. And in my submission, no one could sensibly think, just looking at this case in any depth or thinking about what it might stand for, that was the position as a matter of Jersey law, whether before or after this decision came out. And the point is that Z Trusts, in my submission, just wasn't dealing with the issue in this case. Z Trust was about whether the appointment of trustees was exercised in the interests of creditors or beneficiaries. It was not to do with, and it didn't consider, a power of sale, and the questions that follow, including how much an asset should be sold for, where there is a real prospect of that sale significantly exceeding the relevant debts. So, and the other crucial point which we make, and I think Malone Friend referred to it, is that Z Trust was a cash flow and balance sheet insolvent position. So in that case, the court wasn't considering what the situation would be if in fact there was a balance sheet solvency as opposed to a balance sheet insolvency. And one sees that at paragraph, I think, 39, which is 2 pages further on at 766. So, in my respectful submission, Z Trust is not authority for the proposition for which Malone Friend contends. But even if Mr. Emblin and Mr. Reed had given evidence that they were relying on Z Trust, which they didn't, we say we wouldn't have been short of material on which to challenge that knowledge or belief, because the proposition for which it stands, we say, can't be the right one. But the real point is that there's no evidence that they were considering it at any point in any event. So that's Z Trusts. And then we come to the emails on which Malone Friend relies. And the first was an email from Mr. O'Shea to Mr. Emblin and Mr. Reed on the 13th of May 2019, which I think appears in the supplementary bundle at page 208.
What page did you
Sorry, beg 208, I believe.
Oh,
Supplementary bundle.
I misheard you, my fault. Thank you.
if the court has that in front of it, the first point to make before I even go into it again, I make these points in this order deliberately, that of course, again, and I feel like I'm repeating myself, neither Mr. Emden nor Mr. Reed referred to these emails in their witness statements. Neither of them said that they relied on the emails or thought they were important or took any principle of Jersey law from them. And Malone and Friend referred you to this email, and in particular, he asked you to look, I think, at numbered point 3, halfway down it. The trust will therefore arguably be insolvent, being another key reason why Pinotage will wish to sell the loan book to help it satisfying such professional fees. But the first point I'll say about that is, well, just leaving aside that that is something of a construct to help justify actions, in my submission, the point doesn't help Malone and Friend at all, because all this point says at its highest is that the trust's argued being cash flow insolvent gives the trustee a reason to want to sell the assets. But in principle, I don't think anybody disagrees with that point, because a sale in and of itself was never the issue in this case. It may well not be improper to sell an asset where there are liabilities that are required to be paid, as the judge well appreciated. But in which case, why not only sell, for example, such part of the assets as are necessary to cover those particular debts at proper value? The real issue is, it's the manner in which the disposal was created, including and in particular the cap on the consideration payable for the assets. It's not the fact of the sale, it's effectively the price or the manner in which the transaction is put together. And this point just doesn't address that at all. And this email...
I suppose you might say that if they had had Z Trust in mind, they could have gone rather firmer than saying that the trust will therefore arguably be insolvent.
My Lord makes an extremely good point. And in fact, one of the points I was going to say about this email, and a couple of other documents in a moment, is that if one reads, because we're taking sort of points out of context, I'm going to make a point about island hopping in a moment in terms of the evidence in the case generally. But if one reads this email as a whole, and the judge, you'll recall, set out this email in full in the judgment. So he wasn't unaware of it, he had thought about what it meant and what he was saying, and I'll explain what he concluded about the correspondence generally. But at the beginning of the email, we have Mr. O'Shea saying he's discussed the matter, and the first issue was actually about how the invoice was addressed, because there was concern about funds being held on trust for the beneficiaries, and so they wanted to have the invoice issued by Hatstone rather than Pinotage. But he said, in addition, 100k for a potential 300 million to 400 million loan book is hard to justify from a trustee perspective. And then he goes on, and you'll see at point 4, when he's explaining his new proposal, that Pinotage agrees to sell the loan book to the SPV on the basis the SPV agrees to pay Hatstone from any proceeds it recovers. Hatstone will agree to this. The value to be paid for the loan book can be agreed, but can be up to $1 million, which can be a more realistic purchase price. And at C at the bottom, he says, well, there's going to be a reason to sell the loan book, and the value will be potentially more reflective of the market, etc. Well, the point we were going to make, or one of the points I might make about this document, is that if in fact everyone thought about Z trusts and thought that it stood for the proposition that you didn't need to care about the market value or the value of the loan book, because in fact that authority was authority for the proposition that you could just simply disregard the residual economic interest of the beneficiaries and sell the assets for whatever the creditor wanted. These points just don't arise. They're just not relevant at all in my submission. And so our point in part on this is that actually these emails ultimately don't help Malone Friend, because they betray that Mr. O'Shea is communicating his concern about questions of what this looks like from the outside, seeking to try to justify it. And that is how the judge characterised the correspondence between the parties. What the judge found, based on the evidence as a whole, including all the correspondence that he went through, was that Mr. O'Shea, Mr. Emblin and Mr. Reed were, I think he said, looking for ways to justify their design of the disposal. That's, I think, paragraph 299 of his judgment, but were not satisfied that what they were doing was legitimate. And in my respectful submission, these emails are simply examples of that process in action. And what we say Malone and Friend cannot do, what the appellant cannot do, is try to extract those emails from their full factual context to justify a contrary conclusion. That is precisely the sort of island hopping that this court deprecates, which was mentioned in Volpe. And again, I'm not sure, obviously a well-known authority, and I think my Lord Justice Nails sat in that case as well, but for your reference, it's at Authorities tab 48, which is in, I think, bundle 4. At page 1307, it's paragraph 65 of Lord Justice Lewison's judgment, where he sets out a series of features of appeals which seek to turn over findings of fact. But the court clearly deprecates the idea of island hopping, and for good reason, because one has to look at all these documents in their proper context. And just so you are aware, I'm sure you are, this was a document-heavy case. I think there were 4,300 or so pages in the trial bundle, and the judge spent 15 or so pages going through the narrative in great detail, so you will have picked up from the judgment how factually complicated it was. So that was the first document. And the second document, I think, was page 227 of the supplemental bundle. And the relevant part the learned friend referred to was sort of the end of the last full paragraph of about 6 or 7 lines. It's an email sent in the context of amendments made to the sale and purchase agreements in relation to the acquisition of these assets out of the trusts. But in the last section of that paragraph, Mr. O'Shea is somewhat tentatively setting out an explanation of how the consideration, which I think he even puts in apostrophes, has been calculated, i.e. by reference to outstanding creditor charges, with the creditors agreeing to accept deferred consideration. And the last line, we say, is just another example, as the judge found, of self-justification for the sale generally. It simply says that this justifies the sale contrary to the best interest of the beneficiaries, because the creditor's interests arguably usurp or trump the beneficiary's interests. But again, it doesn't go anywhere near the question of Z Trust being justification for disposing of the residual economic interests, or even the disposal of those residual economic interests themselves. It is just a justification, an attempted justification for the sale. So, my lady, my lords, we say that those documents do not assist. I will come on to 1 or 2 other documents in a short while if I need to sort of reinforce the point, but I think you have the point I'm taking. The next point that I just wanted to raise very briefly, although you weren't taken to it, we probably don't need to, is Malone Friend points to the fact that in relation to those documents, Mr. Emblin and Mr. Reed were asked by him in cross-examination whether they had any reason to doubt what they were being told, and they said they did not. The points we'd make about that are as follows, and they're essentially 2 points. The first is that if that was an attempt to adduce material to support a new case not given in evidence in chief, effectively, that the first appellant did not have a knowledge of a relevant feature of Jersey law, then in my submission it was impermissible as an attempt to introduce via re-examination just fresh material. It wasn't responsive in that sense to any topic in cross-examination. I think the whole point, Malone Friend's whole point is that the Mr. Emblin and Mr. Reed were not questioned about their knowledge of Jersey law for very good reason. They didn't provide any evidence that was ever a relevant feature of their knowledge or otherwise. And of course, if Malone Friend had wished to change the case that the appellant was advancing at trial, it would have no doubt had to try and adduce further evidence and adjourn the trial and take all those steps, which seems an extremely unlikely proposition, given we're at day 4 of the trial. But that just illustrates why you can't sort of get anything in like that on re-examination. But the real point is that the answers in re-examination come nowhere close to establishing that Mr. Emblin and Mr. Reed believed that the transaction was lawful as a matter of Jersey law. They don't say that they relied on the emails or took anything from them in particular, or that they understood them to be advice on Jersey law. So we say that they don't provide any evidential foundation for the points now being alleged. It's worth bearing in mind, my lady, my lords, that the judge had all of these submissions, and he had all of these documents and answers in mind, and still assessed the evidence as he did. Had it been the first appellant's case, we say, that Mr. Emblin and Mr. Reed believed it was impermissible under Jersey law for the beneficiary's economic interest to be entirely disregarded, then firstly they would have said so and would have had to say so in their witness statements. And they would have needed to have identified properly the basis upon which they formed that belief. And then, of course, we would have had an opportunity to cross-examine them on it. But none of that happened because it wasn't their case and they didn't have the evidence to support it. And I might observe, if I may, that it's not surprising that the first appellant didn't put its case that way, because, as the judge explained early in his judgment, neither Mr. Emblin nor Mr. Reed were inexperienced or naive when it came to dealing with Jersey trusts. You'll remember that Mr. Emblin was an accountant, Mr. Reed is an English law solicitor who specialises in trusts. And they both had a considerable experience of working with offshore trusts. And it is a noteworthy point that, in fact, it was Mr. Emblin and Mr. Reed who purported to provide advice to the trustee in relation to its options for the purposes of the sale or the disposal. I say sort of purported because, of course, they were the counterparties to the transaction. So it wasn't advice in the sort of independently taken advice. It was, again, this exercise of creating documents to seek to justify things. I might just show you, if I may, in the supplementary bundle, at page 213, the relevant document.
So this is your own bit of island hopping, is it?
Well, it helps to put, I think, the documents my learned friend relied on in some context. But I take the point, my lord.
Positive archipelago.
Yes, indeed. At page 213, we have an email from Nicola Stone at Reed & Co., who attached a report that she said was prepared for Hatstone regarding the options available to Hatstone's client, Pinotage, as trustee of the various trusts. And if I can ask you to then follow on to the next page, you have that report, Options for Trustee, authored, it seemed, by Mr. Emblin of Reed Co. And if one skips on to 220, the relevant passage I was just going to refer you to briefly was this option 5, because the report set out 6 options, but it only suggested one as a viable option, which was the sale of the debt book. And the court might want to just briefly read what is said there. In particular, you'll note that the second sentence suggests that the proceeds after settling the trustee liabilities could then be appointed to beneficiaries who would then have cash to pay any tax charge arising thereon. So in this advice, in this note, it's supposed that actually the beneficiaries, or the trust, would get the proceeds over and above the liabilities back. And for that reason, presumably concludes in the last line that the sale would be in the best interest, in the interest of the beneficiaries. But there is no mention anywhere in this document, which comes after the email of the 13th of May you were taken to, any mention of Jersey law or Z trusts or anything of that nature. And of course, had it been in firmly in Mr. Embley and Mr. Reed's mind what the position of Jersey law was, no doubt that would have appeared. Now, this report, I mean, one has to take with a pinch of salt because it was produced not only after the first appellant had been incorporated, but after the deposit of £100,000 for the sale of the loan book had already been paid. So it isn't, as you, one has to look at these documents, as we say, quite carefully. And one can move further on to page 223 of this bundle to another email, this time of 21st of July 2019, so a couple of months later, Mr. O'Shea to Mr. Reed, saying, "Hello Mark, sorry, just thinking, did we get a rough valuation of the loan book? I guess it may be helpful to have a rough idea of what £1 million of old and bad debt is worth. It's the kind of information which may be good to include in a trustee resolution approving the sale." And Mr. Reed's response to that, which follows on the next page, is to tell the trustee that the trustees would appear to have ample reason to sell this debt at a level sufficient to recoup most of their outlay and costs, because, on the basis, he says, because the trustees have deemed in not actual knowledge that 99% of the debtors are insolvent. And after the bullet points, he says, in short, the trustees, contrary to their expectations when they became trustees, consider that these books of debts have nothing but a notional value at best. Now, that email the judge considered to be seriously undermined in terms of its truth or reflecting Mr. Reed's true position by the fact that in a later email, Mr. Reed complained that the fact that 800 debts might not be transferred to FS Capital would be the loss of a huge commercial opportunity. And if you wanted to see that, it's 2 pages further on at page 226 of this supplementary bundle. The point I'm seeking to make, my lady, my lords, and I'll stop there, is that when one actually looks at some more of the documents, you can see a complete absence of this reference to the point that the learned friend seeks to draw. And not only that, but you're having questions such as, well, have you got a valuation of the loan book? Questions which in our submission are just inconsistent with the point they're seeking to advance, because the valuation would be irrelevant if they were right about Jersey law or their belief in it. And in any event, my lady, my lords, we take the point. This is island hopping. The judge assessed all of this evidence, and he formed a view, and there's nothing to disrupt or upset that view. So we say the judge, to sort of tail off this part of my submissions, the judge was obviously right to find, in paragraph 303, that the first appellant had simply not advanced a case that they were unaware that Jersey law prohibited a trustee from disregarding the interests of beneficiaries, as took place in the disposal. And he was right to find that they'd not made out that defence because it was impossible for them to do so on the evidence they advanced. So we say what is being argued now is a sort of reverse engineering based on a bad reading of a case they didn't know about. And that's what we say essentially. And that really deals, I think, with the evidential part of grounds 1 and 2 and why the whole thing should fail. The point I was going to move on now for 15 minutes is this point about the inconsistency in the unchallenged factual findings I made and the findings the judge made about whether it was legitimate, whether they knew it was legitimate or not.
The no room point.
My no room point. No room for a separate finding about knowledge of breach of Jersey Trust law. So the second reason we say that this part of the appeal fails is that the judge made findings with which it would be inconsistent to say that the appellant did not know the disposal was a breach of trust as a matter of Jersey law. Now, I can probably take this part of the submissions rather quicker than I would, because my submissions were that this part of the appeal proceeds on effectively a false premise But the only finding that the judge made as to the knowledge of Mr. Emblin and Reed concerned the knowledge of the facts of the breach of trust, i.e. the details of the transaction. And we say, as I've tried to explain briefly already, that that's not right. The judge went further and made a finding as to what they were thinking about the propriety or legitimacy of the transaction. And one sees that, as I say, in Core Bundle 1, I think it's page 292, at 299 of the judge's judgment. And what the judge says there, after having set out the learned friend Mr. Morgan's arguments, he said, "On the facts of this case, I cannot accept this argument. It seems quite clear to me, and I so find, both from the evidence of Mr. Emblin and Mr. Reed and from the evidence of the contemporaneous documents, that neither Mr. Emblin nor Mr. Reed was or could have been satisfied that it was legitimate to disregard the interests of the beneficiaries." And if one goes on to 305, which is at the very top of page 294, his lordship makes a similar finding when he tests the question about knowledge of Jersey law. And what he's saying there, we say, is that he explains that he's found, he sort of summarises the findings, and he said, "I found that Mr. Reed could not have been satisfied and were not satisfied that it was legitimate to disregard the interests of the beneficiaries in this way." So that's his finding. Then he goes on to say, "Given this state of knowledge, it strikes me it would have been perverse if this had been the evidential position, that the first defendant could have escaped being affected by the breach of trust, which resulted from the design of the disposal, on the basis of evidence from Mr. Emblin and Mr. Reed that they did not know that their design of the disposal would constitute a breach of trust under Jersey law." So essentially what he's saying is, having found, as I have, that this is not legitimate, there's no further room for an argument that, or there's sort of no distinction, there's no room for argument that you don't know the technical requirements of Jersey law. And as he say, it would be perverse. Now, we say that that corresponds to the legal position on these questions, because the learned friend suggests that the judge ought to have gone on to find that that they did not know that disposal was a breach of trust as a matter of Jersey law. We say, in that sense, it's tantamount to saying, well, unless you're a Jersey lawyer, or unless you know the niceties of Jersey law, you will always be able to avail yourself of a bona fide purchase defence. We say that's wrong, as a matter of principle, because a person can have actual notice that a transaction is in breach of trust without a full appreciation of the legal analysis of the transaction itself. And it doesn't matter whether they can describe the transaction in precise legal terms. The reason I say that this argument might be slightly shorter is because my learned friend this morning, I think, conceded that in Sinclair, the test is about whether someone has notice, and in our case, it's actual notice subject to my respondent's notice point. Actual notice that the transaction is probably improper. And that is something that can be seen in other cases as well. We've referred in our skeleton, I'm not sure in light of my friend's concession I need to take you to it, but it's in the Papadimitriou and Credit Agricole case in the Privy Council, which for your reference is at tab 39 in bundle 2 of the authorities bundle, and in particular the head note at E to F.
Just give me the tab number.
Beg your pardon, my lord. Tab 39.
No, I don't need to look at it, but just...
Bundle 2, tab 39.
39.
39, yes. And just for your note, it's head note E to F, in which the reference is made to notice that the transaction was probably improper. Paragraph 2 of Lord Clerk's judgment at 776, where he says the central issue in the appeal is whether the bank was on constructive notice of impropriety. That's the phrase he uses. Then he quotes from Sinclair and Versailles, the passage at paragraph 100 my own friend referred to. And then at page 786, paragraph 21. My lord, did you want to look at that case? That help? I don't know.
Not unless somebody else wants to.
No, fine. Sorry, I thought there was a
Quizzical
suggestion that
look.
might be helpful to look at. I'm sorry, Murray. Right, and then at that last passage, they address the test for burden of proof and say it was for the bank to show it lacked constructive notice of the impropriety of the relevant arrangements. So again, it's this impropriety question. So we say substituting constructive for actual. That was the position in our case. It was for the appellant to show that it lacked notice of impropriety of the transaction, or probable impropriety. The judge found that Mr. Embley and Mr. Reed were not satisfied as to the legitimacy of the transaction, and they therefore failed to prove it did not have notice of the impropriety. And in our submission, there's no further step whereby Mr. Embley and Mr. Reed can pray ignorance of the specific analysis under Jersey law. And that is why we say in 305 the judge tests the proposition in the way he did, and why he reaches that conclusion. And that result is consistent, or at least more consistent, with the passages in the cases my own friend took you to, such as lifestyle equities, where they reaffirm the ignorance of the law is no defence type principle. But the short conclusion to all this is that even if my lady and my lords took the view that somehow the first appellant could establish that the correct question that the judge should have answered was whether it had established that it did not have actual notice of the detailed law of Jersey in relation to a breach of trust, our case is that the appeal must still fail on grounds 1 and 2, because the appellant simply didn't make out that case on the evidence, which is what the judge found.
And so you say what's said in Sinclair by Lord Newburger, that one applies the same test in relation to knowledge of the law or the relevant legal components as to the facts, and that takes him back to paragraphs 98 to 100 or something of his judgment, is a reference to you've got to see overall whether the defendants thought it was probably improper, and that's Papademetriou as well.
Indeed.
And that once you think it's probably improper, then inevitably that connotes not only an anxiety about the factual pattern, but also that it might be unlawful.
Yes.
Because it's improper.
Yes, indeed.
And so I'm just trying to get to the bottom of that issue, because Mr. Morgan says what the judge did, and what perhaps you encouraged him to do, was to run the facts and the law together. And that is, in effect, what you're doing, and so that's why I'm trying to tease it out.
I understand, and it may be right to say that in paragraphs, particularly paragraph 304 of his judgment, there's quite a lot that's compressed. And it may be that one could say that it might have been expressed in a way where one sort of added in the additional step insofar as it was necessary. But the point we're trying to make is that the judge, in fact, made a finding about knowledge of legitimacy, which goes beyond simply knowledge of the details of the transaction, knowledge of the facts. And we say that's why he says in paragraph 305 it would be perverse, having found that, to suggest that there's anything further you could say about knowledge of Jersey law in the technical sense. But yes, my lady's absolutely right. We say that in Sinclair, where Lord Newburger is dealing in paragraphs 102 to 107 with the question about knowledge of facts and whether you impute, you have to be slightly careful, because of course Sinclair is a constructive notice test, and imputation is a concept of constructive knowledge or constructive notice. But substituting that, subject to what I'm about to say next, for actual knowledge, you come back and he says, I've summarised it above, you apply the same test as I sort of summarise in 98 to 100. And one comes back to the point, does the person know that it is probably improper for actual knowledge? Yes, that's what we say.
Thank you.
Conscious of the time, my lady, I'll try and deal with the respondent's notice point briefly, because it would be, I'm sure, helpful to my lady and my lords to sort of clear grounds 1 and 2. And we advance this alternatively to the above submissions, because if the first opponent establishes that it did not have actual notice, then we make 2 submissions. Firstly, that the judge ought to have decided that the relevant standard of notice was actual and constructive notice, or actual or constructive notice. And secondly, that on the unchallenged factual findings, the first appellant would have failed to have proven that it lacked constructive notice. Now, I'm not sure if that is actually in dispute based on the judge's findings as to the underlying facts. So I will concentrate simply on the legal point, which is a matter of pure statutory interpretation of the Trust Jersey law. There's no special rule of construction. If I could take you to the statute which is under tab 1 in bundle 1 of the authorities bundle, pages, it's page 8 to begin with, we're looking at.
Smile, I was next
sorry,
down that last submission, so the page reference again.
It's page 8 under tab 1 of bundle 1 of the authorities. My lady, my lords, I'm sure will have already read 54.3 and 55.1. We say that it's undoubtedly the case that the two provisions don't sit comfortably with one another, because the court either has to ignore the fact that actual is not used in 54.3, or one has to read that Article 55 in a way that distinguishes it from what Article 54.3 is doing. Now, we say the latter is the correct answer. There is obviously a deliberate choice to use actual notice in 55.1 but not in 54.3. And if 54.3 is to be read subject to Article 55, as my learned friend and the judge said, then it's strange, we say, that Article 54 did not refer to actual notice or say subject to. The answer, we say, is that they are doing different things and they're concerned with different things. Now, Article 54.3, one reads it, undoubtedly concerns proprietary claims, and I don't think that proposition is disputed. So it is expressly concerned with a situation where the claimant is following and recovering trust property itself and says nothing about the personal liability of the person from whom the property is recovered. So you see that because it's effectively the object of the clause. Without prejudice to the liability of a trustee for breach of trust, trust property, which has been alienated or converted, may be followed and recovered when it's in the hands of a bona fide purchaser for value without, unless it's in the hands of a bona fide purchaser for value without notice. So Article 54.3 is, I think, on any view, about proprietary claims and following. Article 55.1, we say, concerns personal claims. We say that, and we say it is, you can get that from the language, contrary to what my own friend said. Its focus is on, and the subject is on, the bona fide purchaser themselves. So a bona fide purchaser for value, without actual notice, may deal with a trustee in relation to trust property and shall not be affected by the trusts. Properly interpreted, we say that that means it's lawful for a bona fide purchaser without actual notice of breach of trust to firstly deal with the trustee as if the trustee is the beneficial owner of the trust property, and to not be affected by the trusts on which the property is held in the sense that they will not be personally affected, i.e. incur personal liability. What we say it doesn't do is exclude the right of a beneficiary to recover the trust property under Article 54. And we say there is a good reason, in principle, why one might want to legislate for that difference of approach. And that is simply because a proprietary claim requires a defendant to return property that isn't theirs, or was never theirs, and a personal claim is much more onerous. It subjects the defendant to personal liability of trusteeship. Now, we say that distinction is reflected in English authorities. I just want to make a point about that. The learned friend said the position in English law at the time wasn't this. That may be so. That's not the point we're making. We're just using an English case as an example, showing the distinction to show you why there might be some good reason. And if my lords and my lady will permit me an additional 5 minutes, I'll finish that point off. It's Re Montague Settlement Trusts, which is bundle 1 of the authorities bundle, tab 23, and it starts at page 248. Decision of Sir Robert McGarry when he was Vice Chancellor. And it's a case, my lady, about personal liabilities for knowing receipt, which is referred to in this case as liability to account as a constructive trustee. So I just say that because the label of constructive trustee is being used in respect of personal liability. And if one could turn to page 206 of the report, there's a passage between B and C where Sir Robert McGarry says, that brings me to the essential question for decision. The core of the question, and I put it very broadly, is what suffices to constitute the recipient of trust property a constructive trustee of it, i.e. personally liable in respect of it. I can leave on one side the equitable doctrine of tracing. If the recipient of trust property still has the property or its traceable proceeds in his possession, he is liable to restore it unless he is a purchaser without notice. But liability as a constructive trustee is wider and does not depend upon the recipient still having the property or its traceable proceeds. Does it suffice that the recipient have notice that the property he was receiving was trust property, or must he have not merely notice of this, but knowledge or cognizance, as it has been put? So that, in our submission, articulates the distinction we say appears in the articles. There's another passage at page 261, just above letter G, where Sir Robert says, it seems to me that one must be very careful about applying to constructive trusts either the accepted concepts of notice or any analogy to them. In determining whether a constructive trust has been created, the fundamental question is whether the conscience of the recipient is bound in such a way as to justify equity imposing a trust on him. The rules concerning a purchase without notice seem to me to provide little guidance on this and to be liable to be misleading. And then slightly further, just over the page at 262, at letter B, he says, third, there seems to me to be a fundamental difference between the questions that arise in respect to the doctrine of purchase without notice and constructive trusts. As I said in my previous judgment, the former is concerned with the question of whether a person takes property subject to or free from some equity. The latter is concerned with whether or not a person is to have imposed upon him the personal burden and obligations of trusteeship. I do not see why one of the touchstones for determining the burden on property should be the same as that for deciding whether to impose a personal obligation on a man. The cold calculus of constructive and imputed notice does not seem to me to be an appropriate instrument for deciding whether a man's conscience is sufficiently affected for it to be right to bind him by the obligations of a constructive trustee. So we say that articulates why there might be one standard of notice for proprietary claims and another standard that applies for establishing personal liability. And the bona fide purchaser test under Article 54.3 is left wider than actual notice, encompassing both actual and constructive notice, because the recipient of trust property is not having imposed on them a personal burden or an obligation of trusteeship. But Article 55 is so confined because it is. And we would say that that is consistent with Article 33 of the Jersey Trust Law, which my learned friend referred to, which is at page 7 of this bundle under tab 1. I disagree with my learned friend. The claims envisaged at paragraphs 33.1 or Articles 33.1 and 3 are personal claims for knowing receipt. In my submission, when one reads those, it's clear that these parts of the article are dealing with a proprietary right in relation to profits, gains or advantages from breach of trust. So when one reads 33.1, which is on page 7, subject to paragraph 2, where a person, referred to as a constructive trustee, makes or receives any profit, gain or advantage from a breach of trust, the person shall be deemed to be a trustee of that profit, gain or advantage. And 33.3 says a person who is or becomes a constructive trustee shall deliver up the property of which the person is a constructive trustee to the person properly entitled to it. So we say that's dealing with a proprietary right. But Article 33.2 says that paragraph 1 shall not apply to a bona fide purchaser of property for value and without notice of a breach of trust. That's the wider constructive notice. So that is consistent with the proprietary claim analysis in our submission. So we say that the judge very respectfully was wrong to conclude as he did that the correct standard of notice was only actual notice. We say that properly construed the statute, 54.3 applied, and it wasn't subject to a gloss in the form of 55.1. And my learned friend had, I think, 8 points, I wrote them down correctly, where he said that the judge was right, 5 from the judge and 3 from him. But of those, actually, we say they don't pass muster, because he said that, well, these aren't to do with, the first one may deal with very wide and can deal with the purchase of property. Well, yes, but that's not really the question. The question is about an imposition of a personal trusteeship. Now, good policy reasons, well, I've explained a different policy reason as to why one might put a different standard of notice on. We say that the language does say that you can read Article 54.3 the way we say in Article 55 is about personal obligations. He says it's difficult to see how there could be a reference to alienation and it's clearly wide enough to cover sale and purchase. But as I say, the point there is not about whether there's a sale or purchase. It's about whether there's a proprietary right in a claim or a personal right in a claim. The question about whether you can purchase and sell property through a trustee is not relevant. But there's another answer, which is that on one view, anybody who receives trust property is dealing with a trustee. So it's difficult to see, because for it to be trust property, the person who had it before must be either a trustee or a constructive trustee. So it's difficult to see how one can sort of draw a distinction about dealing with a particular trustee. And I think I've answered the rest of the points he made through the submissions I've already made. So conscious that it's 22 minutes past 4, my lady, and subject to any questions, of course. I don't want to rush too much. Julia, I can always answer them in the morning or now.
No. First of all, have you said everything that you need and want to say on this topic? I don't want you to feel that you have not.
No. I believe I have, my lady, subject to anything my Mr. Fenimore tells me. No, I think
Mr. Fenimore is content anyhow. Thank you.
Thank you, my lady.
Any questions? I just have one question, which isn't specifically for you, but I notice as you've been taking us to the provisions of the Jersey Law 1984, that the copy that we have in the authorities bundle says it's showing the law as at the 14th of February 2023, and I assume that there's nothing that ought to concern us about that.
I will double check overnight.
I'm sure there probably isn't, but it would be helpful to be certain.
I think the articles were originally numbered differently. So
Right.
if you looked in the original version, what is now 54, 55 and 33, but I think both of us looked at this at first time round, there weren't any material differences in respect to those sections.
I'm very grateful.
But we can double check.
No. Now, how are we doing as far as time goes?
I think we're doing better than we expected. I had not expected to finish all of 1 and 2 and respondent's notice in the 45 minutes that I think had originally been allocated to me, but I started early because of
You sorted
learning friends'
earlier.
You
efficiency.
started half an hour early.
Indeed.
You
So
did.
I think we are better off, and so I think in the morning, I suspect Coulson's story and ground 4 will take an hour and a half or 2 hours, something like that. My learned friend Mr. Fenimore is going to present the arguments on behalf of the respondent to Mr. Flavin's appeal, and I think he thinks he'll be 30 to 40 minutes approximately. So there
Thank you.
should be plenty of time.
I'm not putting anyone
Within the
under any
time frame.
pressure at all. I'm just trying to discern whether it's necessary that we start early tomorrow or not. And it seems that the answer is not. We're perfectly content to do so if it's necessary.
For my part, my lady, I don't think it is necessary.
Thank you very much indeed then. 10:30.